I was asked to consider what role Council played at various stages of development and construction of the Bella Vista subdivision, and to express views about whether its performance of various regulatory functions was adequate or not. I was also asked to make recommendations as to future action in light of discussions that have already taken place between Council and homeowners. For the benefit of all homeowners and the media and yourselves, I want to emphasise how cooperative and transparent the Chief Executive Officer and his team were in facilitating my investigation. They all deserve credit for the willing assistance they provided. I would like to thank in particular Gary Paul, Kirsty Downey, Jeremy Bose and Rob Goldsby for their assistance. They provided answers to all of my questions and my requests for documents promptly, and it does not go too far to say that I would have struggled to provide a report within the specified time had they not cooperated in that way. I think it's important as elected members that you understand how well your officers dealt with the aspects of this inquiry. My conclusions may be summarised as follows. The Council dealt adequately with the resource consent applications made in respect of the Bella Vista subdivision. Second, the Council did not perform adequately its monitoring and enforcement functions under the Resource Management Act. My concerns are focused on geotechnical aspects of construction works required before the dwellings could be built. The Council performed building consent functions adequately for those issued before 23 December 2016, but failed to make appropriate inquiries in respect of those granted on or after that date. In the period between 24 August 2016 and February 2017, the Council came into possession of considerably more information about, in particular, construction of the necessary retaining walls. That accounts for the different approach I have taken in respect of consents granted before 23 December and on and after that date. There are a number of photographs in the report to illustrate the state of those works at various times, and if you want to look briefly at paragraphs 158, 159, 160 and 179, just to get a flavour of that. And I'll pause for a moment so that when the homeowners have an opportunity to do this, they can do so before I continue. Fourth, the Council did not perform its Building Act inspection functions adequately in respect of both geotechnical and structural considerations. Fifth, the Council ought not to have issued code compliance certificates for 297 and 311 Lakes Boulevard and 2 and 4 Aneta Way. Next, it was appropriate for the Council on 16 April 2018 to declare all buildings in the Bella Vista subdivision either dangerous or affected on the basis of the professional advice it received on or about 15 April 2018. There are two discrete aspects to my recommendations. They are first, the need for prompt resolution of immediate issues that arise as between the Council and homeowners. The second is the need to investigate why the council failed to meet regulatory obligations I have identified. If I can now make some preliminary comments which will be more focused on homeowners and the media. I cannot emphasize enough that my findings that the council did not perform its resource management, monitoring and Building Act regulatory functions adequately do not mean that the council is necessarily legally liable to homeowners who have suffered loss. Liability is something on which the council needs to take its own legal advice, and similarly, the homeowners need to take their advice. Deliberately, I have used the word adequately in my report so as not to address specifically the elements of potentially available legal claims, such as negligence. If legal proceedings were to follow, a number of issues would arise. Without being exhaustive, the questions would include: what is the nature and extent of the council's duty of care to homeowners in the particular circumstances of this case? Is there a sufficient causal connection in law between any actionable acts or omissions on the part of the council and the loss homeowners have suffered? To what extent are losses suffered by homeowners recoverable from the council? And are there any other parties who should bear responsibility and share the burden of any loss for which the council could be liable? Nor can I emphasize enough that my report is not directed to the question whether any person other than the council may have failed to act adequately or inadequately in respect of standards fixed by law and any duties owed to homeowners. Although in my report I have set out in some detail the nature of issues that arose between the council and Mr. Cansian as director of Bella Vista Homes Limited, nothing in my summary should be taken as expressing any view one way or the other on the merits of any claims that might be made by one against the other. Some background has been included for the sole purpose of providing context in which council performed various regulatory functions after those disputes arose. I cannot, on the information available to me, resolve those differences. Having said that, I have made a number of factual findings that plainly speak for themselves. Deliberately, I have not named or attempted to ascribe blame to any particular decision maker or inspector in respect of those council functions that I have found were not performed adequately. As I did not have any power to compel any person to answer questions or produce documents, I elected not to talk to any of them. As a result, no adverse inferences should be drawn against any of those people. Similarly, although I am obliged to accept the views of the geotechnical and structural engineers as to defective aspects of the construction work, I am not endorsing any express or implied criticisms of any particular products used in the building work. I did not investigate whether any particular products were or were not fit for purpose. And as I have noted in the report, those expert opinions on which I was asked to rely have not been robustly tested. I turn now to my recommendations. Because the recommendations, particularly the first, are likely to be of greater interest to the homeowners, I explain them in more detail and then give my reasons for making them. First, I recommend the council take immediate steps to resolve outstanding differences between the homeowners and itself. As the council is in reality the last target for litigation from which recoveries are likely, in a practical sense, I consider that the benefits of early resolution outweigh any desire to have the homeowner's claims tested in court. Second, there is a need for some inquiry or investigation to ascertain why the council failed to perform adequately relevant regulatory functions. There are a variety of options available to conduct that type of review. I favour an approach that avoids the possibility of a witch hunt in respect of the actions or omissions of any particular council officers, and focuses on what lessons can be learnt from the failures to minimise the risk of something like this happening again. Having said that, there will undoubtedly be some need for accountability. As to the first of those recommendations, because the council is the last realistic and available target for legal proceedings, there are good legal, economic and humanitarian reasons for the council to acknowledge the shortcomings in its performance of regulatory functions and endeavour to effect a swift resolution of any disputes with homeowners. The factors I suggest that you take into account are these. First, the direct costs to the council of involvement in court proceedings. They obviously include the costs of your lawyers, experts, and so forth. The second are the indirect costs involved in diversion of the time of senior council executives and officers from their core responsibilities to attend to court proceedings. The third is the risk that any defence might be unsuccessful, and in my view that is significant, particularly on the inspection issue. The fourth is the possible consequence of an unsuccessful defence being the award of a significant sum of costs against council. Given those factors and taking into account the trauma that the innocent homeowners have suffered, I recommend you consider carefully negotiating a prompt resolution that will address both the financial losses and emotional harm suffered by the homeowners. The next issue involves the need for a further investigation into why the events unfolded as they did. In my view, an independent investigation is critical. Although there is no mechanism by which an appointed investigator could compel someone to give information or produce documents, I consider that a process that would enable those who have participated in events to speak about their experiences and to explain what occurred would be both cathartic to homeowners and instructive to council in the management of similar regulatory functions in the future. From a transparency perspective, an investigation such as this will also have the benefit of helping council to understand why these events occurred, and that is something that is equally important to ratepayers to understand more generally. The type of inquiry I am suggesting is designed to be constructive. I am not in favour of anything that would create an unnecessary distraction and be little more than some form of bloodletting exercise. That would not be a suitable mechanism to deal with this question. As long as council is prepared to engage promptly to resolve disputes with homeowners, my recommendation is that this investigation be deferred while that is done. Resolution of issues with homeowners is the most important aspect. Otherwise, I consider it should be undertaken immediately. I will now provide brief reasons for the conclusions I reached. While I retain residual concerns that those who processed the resource consent applications did not obtain confirmation from Coffee Geotechnics that its report for the Lake subdivision remained applicable to the smaller Bella Vista subdivision, on balance, I have concluded that they were entitled to rely on representations from Harrison Grierson that minimal earthworks were required for the subdivision stage of the project. I emphasised the distinction between earthworks required for the subdivision to be completed on the one hand and those necessary to build dwellings and retaining walls on the other. To suggest that those responsible for processing the applications were required to make further investigations in those circumstances would, on reflection, I consider being a counsel of perfection. The monitoring and enforcement functions of the Environmental Monitoring Office were of three types. First, there was an obligation to monitor the resource consents. Second, they were required to monitor continuing conditions attaching to the resource consents after the subdivision had been physically completed. Third, they were required to monitor compliance with relevant parts of the city plan. The point on which I criticise those responsible for monitoring and enforcement involves the extent of earthworks that were undertaken on these subdivision sites. There is clear evidence that they exceeded the single cut permitted by the relevant provision in the city plan, yet no steps were taken to rectify this. It is clear that the monitoring office was aware of activities because it did issue an abatement notice in respect of another aspect of the same rule dealing with erosion and sediment control measures. In my view, the enforcement officers missed the more serious concern by not issuing abatement notices in respect of the retaining work. I have accepted that building consent applications were properly granted up to 17 August 2016. I give the benefit of any doubt to those responsible for processing the applications that there was insufficient information to refuse consent. But from 24 August 2016, the Council became aware of significant problems that were never properly addressed in the subsequent building consent applications. The differences between the original plans and the extent of earthworks at 4 Aneta Way around that date are depicted vividly in the drawing and photograph, which is reproduced at paragraph 179 of the report, and if I could just ask you to look at that briefly. I've provided two examples in my report relating to consents granted from 23 December 2016. One related to a consent granted on 24 February 2017 and the other 2 August 2017. I picked those dates at random, and if you would like to have a look at paragraphs 173 to 177, they summarise what I found. The Building Act inspection functions were undertaken inadequately. Two major problems have emerged. One concerned geotechnical considerations The other involves structural aspects of the dwellings. I have summarised those concerns at paragraphs 204 and 205, respectively. In short, even a non-professional can go onto the site today and realise that a lack of a retaining wall between the Aneta Way properties and those on Lakes Boulevard is potentially dangerous. As I said at the public meeting on 8 May, you would need to be blind not to realise there was a retention problem. While in the report I have referred to geotechnical evidence confirming why there is a problem, I need to say no more than I have. The second is that there are major structural problems across all of the dwellings. All need remedial work to greater and lesser extents. The list of defects identified in BCD Group's report of 12 April 2018 is sobering, to say the least. They are summarised at paragraph 205 of the report. All of the defects were there to be seen at the framing and pre-wrap inspection. As with the retaining wall problem, it is difficult to see how anyone could have missed them. If I can just invite you to look at paragraphs 204 and 205 just to get a broader understanding of those issues. In my view, the council was right to issue dangerous building notices. On the basis of the evidence available at 12 April 2018, the safety concerns were such that the council had little option but to take that step. I'm satisfied the council acted in good faith and for proper purposes in declaring the buildings dangerous. The sad part is that the problems were not identified earlier and this state of affairs emerged. I have also concluded that the council ought not to have issued code compliance certificates for 297 and 311 Lakes Boulevard and 2 and 4 Aneta Way. In light of the extent of geotechnical and structural problems that were not identified during inspections but ought to have been, there was no basis on which council could have been satisfied on reasonable grounds that relevant building works complied with the consents and the building code. Significant remedial work is still required in respect of those properties for which code compliance certificates were issued. I made some comments on the availability of remedies that could have been used by council when it became aware of geotechnical and structural problems of the magnitude identified. The Resource Management Act could have been used through abatement notices or enforcement orders. Under the Building Act, the notice to fix regime would have required activation. In the course of my investigation, I came to understand that some legal impediments existed that council considered might prevent the notice to fix process from being used. I have offered some views on that topic for the future, which I hope will be of assistance. That is a relatively short summary of my conclusions and recommendations and the reasons for them. I am conscious that while councillors will have had an opportunity to review my report fully, homeowners will not have had it until just before this presentation is played. Clearly, they will need time to digest the findings. I can only hope that my endeavours will lead to resolution. Under the terms of reference, my role now concludes after I have answered questions from you. For the benefit of homeowners and media who will watch this presentation later today, I make it clear that I will not respond to any further questions about this report, nor will I make any further public comment. Apart from the comments made to you in answer to your questions, the report must speak for itself. I would not regard it as appropriate for me to undertake any investigation into why the events occurred. That is a wider brief, and I would not want it to be thought that my views were coloured by the findings I have already made. Accordingly, if a further investigation were undertaken, I would not be the right person to appoint. I am happy to take any questions you may have. At this stage, I thank the homeowners for their later attendance and hope my report will be helpful to them. And I will now cease this presentation so that the rest of it can be conducted in a confidential way with councillors.